Welcome to the webinar. We're just waiting for all the participants to join. In the meantime, yeah, you're welcome to use the chat. It's great to have everybody here. In
Welcome.
fact, if you want to post, where you're from, what company you're from, it's cool for us to be able to know who you are and who we're sort of chatting with, because it's so one way. Hey, Sophia. Awesome. We've got people east to west coast, it looks like.
Sylvia, I was just out in BC doing some training.
Very cool. Saskatchewan, really all over.
Nice to see it filling up in here.
Yeah, it's looking good. It's great. I assume a lot of people who are going to be on the call today are HUMI clients, and it's awesome to see sort of everybody from all over the country. Being a software company, not having offices everywhere, it's sometimes easy to forget that we're working with people in every single province, every single territory. Oh, Nate, it looks like Nathaniel, looks like you're going to have some competition here. We've got a lawyer on the call.
Asterisk, not employment law though, so thanks for that, Luke.
There. We're, our plan was to start this year sort of 5 minutes past the hour to give some people time to join. Looks like there's still a bunch of people joining, so we'll maybe wait just another minute or two. There's a lot of content to get through today, so hopefully we don't run over. But if we do, we're definitely open to extending this into a second webinar if necessary, because there was a lot of interest, a lot of questions, and obviously a ton of content here. Well, you know what? It looks like the growth in sort of viewers is slowing down here, and we're eating into the hour. So why don't we kick it off? Quick introduction. My name's Simon. I am one of the two CEOs at HUMI. This is my second technology company startup. Originally, I worked in finance throughout the last recession. It was an interesting place to be. I was really on the front lines in terms of seeing a lot of the changes that affected that industry. Obviously, in our current climate, the changes are happening to almost every industry, ours included. Really, nobody's being spared here. And in my role, acting as CEO or co-founder, both in this business and in the last, my job has also been acting as internal HR for a lot of that time. So everything from the legal ramifications of changes in a business, looking over contracts, sending out employment offers. This has been stuff that I do, and so the conversation here today is obviously really dear to my heart. With us we have Nathaniel Marshall. Nathaniel and I have known each other for over a decade. One of the smartest people I know. Turnpenney Milne, his law firm, was ranked as one of the top 10 boutique law firms focusing on labor law in Canada last year in 2019. So we're really lucky to have him with us here today. He's somebody that I turn to quite often for advice, and hopefully the content that he's prepared is going to be able to help us all sort of navigate these waters. Nathaniel, do you want to give a little bit of a background on yourself?
Certainly, and thank you for the kind regards. As Simon noted, I'm a labor and employment lawyer. I've been practicing law in Ontario for 6 years. I'm also called in Nova Scotia, working on getting called in some other provinces as well at the time. As Simon noted, I work for Turnpenney Milne. We're a labor and employment boutique with offices in Toronto and Vancouver. We specialize in all matters relating to the workplace, particularly workplace investigations, employer advisement, as well as employee advisement. So we pretty much deal with the full gamut of labor and employment law and anything it might encompass. So I thank you all for joining me here today. I've got a deck that we're going to go through, and typically we wouldn't do this in the webinar format, but this content tends to be very pithy and it's heavy on the substance. So I hope I can keep your attention through it. Certainly we're going to have the opportunity for you to ask some questions, and I can give you a little bit of direction on those, with the caveat, of course, that none of this is intended to constitute legal advice. This is for informational purposes. Of course, if you have any specific situations that you're dealing with, you can reach out and get that independent legal advice. Otherwise, this is here to help inform you in what is really an unprecedented time right now. I've certainly never seen anything like this in my career, nor have my colleagues who have been practicing for 20, 25 years plus. So we're really into uncharted territory here. So
Daniel, also, just before kicking off, I think it's also worth highlighting, we have received everybody's questions. We're going to try to integrate them where possible. We noticed, and I saw also just earlier asking where everybody is, a number of people from Alberta. As for the information that we're going to be sharing today, most of the responses and Nathaniel's expertise is in practicing Ontario law. There are some differences province to province, and unfortunately, we're not going to be able to comment specifically on some of the different provinces' treatments. But again, coming back to Nathaniel's point, there might be an opportunity later to follow up and get some more specific advice if necessary.
Thanks, Simon. So if it's okay with you, we'll dive into the presentation that we've prepared for you here. Can you see that, Simon?
Yeah, it looks great.
Okay, perfect. So just looking at what we're going to do here today, I'm going to give you a bit of an overview of the framework as the laws apply to dealing with COVID-19 here in Ontario. So some of the common themes that we're going to see arise will be related to the Occupational Health and Safety Act. Certainly safety is a core issue at this time. There's probably questions of work refusals going on, as well as employers' obligations in these circumstances. The Employment Standards Act as well, which sets the minimum standard that all employees are entitled to in the province of Ontario. It's comprehensive remedial legislation that really looks at kind of all aspects of the workplace. So there, I'm going to address a number of prescribed leaves that employees may be able to access. As well, we're going to start with contracts. It's the starting point in really determining any rights and obligations in the employment relationship. So hopefully, you guys will have good employment contracts in place that are equipped to deal with these circumstances and can be responsive to your needs as they may be. Constructive dismissal is a key legal doctrine that you're going to hear a lot about in these times. And I'm going to dive into that in terms of how it applies to the COVID-19 with layoffs, change in work, potentially compensation, and what that means from an employer's perspective, as well as, tangentially an employee's perspective. I'm also going to look at layoffs. This is a question that I've been seeing over and over and over in my practice, with employers wanting to know what they can do with respect to laying off employees during these times. As I'm sure you're aware, there's been a lot of news coming out about what the federal government is doing in response to EI and employees being laid off. So I'll also touch on that as well. And finally, I just want to wrap up with a quick piece on human rights obligations during these times, because there are a number of ways that human rights concerns can be triggered when employers are responding to the COVID-19 crisis. So just as a general information piece, the Occupational Health and Safety Act is remedial legislation in the province of Ontario that essentially guides health and safety in the workplace. Pursuant to the Occupational Health and Safety Act, there's kind of this nebulous concept that employers are required to take all reasonable precautions to protect the health and safety of their workers. This is an extremely fact-specific endeavor. So certainly what will be reasonable in one circumstance will not be deemed to be reasonable in another. So for example, you can imagine what might be required in a factory setting where there's dangerous equipment that employees are working on will be very, very different from what's required in an office setting. So depending upon the nature of your business, what those precautions are going to look like will vary widely. So essentially, in the context of COVID-19, there's plenty of good guidance coming out from the public health authorities as well as your provincial ministries with respect to what employers should be doing. A lot of this probably won't be news to you, but simple things, quarantining workers who have been traveling, particularly those with confirmed or suspected cases. Those employees obviously cannot be in the workplace. From what we've seen, they can't even be at large in society. So certainly as an employer, you want to do your diligence to make sure that anybody returning from travel is following the quarantine protocol and not coming into the workplace and jeopardizing the health of your workers as well as your customers. Certainly you want to keep employees apprised of what's happening with the state of affairs, checking in with your provincial ministries, Ministry of Labor. They have plenty of good information and resources out there to direct what you should be doing in the workplace. Again, making sure that it's clean, sanitized, social distancing in the workplace. If you have the opportunity to separate workers, get that required 6 feet of space between them. These are the measures that you want to be taking right off the bat. As well, you've probably seen a lot of employers just move to outright work from home policy. I think that's the best approach that we're seeing right now. Of course, there are some essential services where employees are required to attend at work, so it's not possible to have everyone work remotely. But certainly where you can have employees working from home, that's the direction that you would want to be taking. Sorry, Simon, I think you're on mute.
Apologies. On that point, we did. Oh, actually, this is you're jumping right into it. It's a question with regard to refusing work. So I'll let you touch on that and then perhaps expand if you don't cover the question.
Certainly. So by a function of the legislation, employees are entitled to refuse unsafe work. Now, there's kind of a few considerations that go into this. One, it has to be a bona fide concern. Employees just can't refuse work on the basis of saying that it's unsafe. It has to present a likely endangerment to their safety and well-being. If that concern is presented, the employer automatically has a duty to investigate that concern. So you're going to want to look into where the employee is coming from. Is this bona fide? What are the reasons to support that this is potentially unsafe work? And then make a determination after reviewing all of the facts. If the employee is dissatisfied with the outcome of that investigation, in Ontario, they have the ability to proceed to the Ministry of Labor to file a formal complaint. During that complaint, all conditions of the employee's employment are frozen. So you can't basically reduce their wages, you can't reprise against them. Punishment certainly is off the table. It is and can be onerous for employers to respond to these claims, but by legislation, they have a duty to do so. So I think where Simon was going is kind of what happens in a scenario where an employee has been deemed as part of an essential service and has concerns about reporting to work. So if that comes to the employer's attention, again, you're going to do the same inquiry, which is determine whether or not this is a bona fide safety concern. So in a hypothetical scenario where, say, you have a Tim Hortons worker, a restaurant employee who's still open, if they say, hey, my colleague has just returned from travel abroad, they're not following quarantine protocol, I'm concerned about the spread of this in the workplace, I would say that's a bona fide concern, and the employee would probably have a right not to work with that individual. By the same token, the employer has the corresponding duty to make sure that the workplace is safe for all of its employees. So it would certainly be poor management and borderline negligent, if not actually negligent, to have that employee who had just returned in the workplace in any event. So again, it's a fact-specific inquiry, and you're going to have to get into the basis upon which the employee is asserting that the work is unsafe.
And so coming back to that, like if you're an employer and you're in a position where you are still operating because it's the nature of your business, you've been deemed an essential service, I would assume that in order to support your case for maintaining your staffing and dealing with any potential refusal of work, you'd want to have a policy in place that outlines very specifically the measures you're putting in place. Is that almost like a prerequisite?
It's not a prerequisite, but it's certainly a best practice if an employer were to do that. This is, again, just uncharted territory. So the more information that you can provide your employees, the better. If you can keep them apprised as to what efforts you're taking, you're following the Ministry of Labor protocols, you're checking in on what the medical officer's health recommendations are for the workplace and adopting those, then those efforts are going to go a long way in terms of defending a claim of unsafe work. Connected to this is the concept of reprisal. So as I mentioned, you don't want to be in the situation where an employee is claiming that they've been punished as a result of bringing forth a health and safety concern, as they're entitled to do under the legislation. These are particularly difficult claims to deal with. They're reverse onus claims usually, so then the employer has to prove that they're doing everything in the circumstances versus the employee having to prove the case. So they're really difficult matters for employees to defend, and if you're adopting these best practices, hopefully you're not going to end up there. So just again, touching on it here, employers can't penalize them. And as I'm going to touch on later, there's the human rights aspect as well. So if there are employees who are, at a greater risk of coming into contact or being affected by the COVID-19, it's going to trigger the employer's duty to accommodate, which is two-pronged. There's the procedural duty as well as the substantive duty. So procedurally, it's often enough that the employer is aware or should be aware that an accommodation issue has been triggered. And then substantively is the actual steps that the employer takes to provide that accommodation. So certainly in this time, human rights concerns are very live. A lot of employers are correctly concerned that they're doing this right and not targeting or taking action against employees in a manner that's prohibited by the code.
That, and maybe I'll touch on this later, but it does strike on another question that was asked, which is that, and again, I know we're going to be getting into the topic of layoffs in a little bit, but if you are going to be terminating somebody right now, not a temporary layoff, but a full termination, how would that potentially interact with concerns like human rights? Are there specific things that people should be taking into consideration just going about a regular termination right now?
I would suggest that any termination now carries an additional degree of risk, given what's going on. It's going to be the unfortunate reality that employers are going to have to terminate employees as a result of, making tough decisions to keep their businesses viable. But certainly you want to be careful not to tread into the scenario where any termination is potentially related to a COVID-19 scenario or another scenario protected by the Human Rights Code. For example, family status, employees who are unable to be in the workplace because of family obligations that they have to provide care. The code is comprehensive and provides a number of protections in that regard. So it's certainly something that you would want to be live to, and particularly tricky about these human rights issues are that the employee doesn't have to demonstrate that that is the reason they were terminated. They only have to demonstrate that it formed part of the reason why they were terminated. So even say, for example, if you had someone who was a poor performer, had not been performing well, say the decision is 80% related to that poor performance, and then again, 20%, well, there's this COVID-19 issue or potential other issue, that 20% will form the full analysis of whether or not that was a lawful termination. So certainly at this time, all terminations, I would say, should be thoroughly reviewed by external legal counsel to make sure that they're bona fide, because there is the additional element of risk right now.
Fair.
Just moving along with a bit, we can probably move along a bit from that substantive portion, but just be aware that if a work refusal is raised, the employer has obligations to comply with not only the Occupational Health and Safety Act, but also to report cases to the Ministry of Labor if they think they could have been present in the workplace. So the Ministry of Labor is monitoring those cases to make sure that employers are taking all steps reasonable in the circumstances, protect their workers and their business as well. Coming into this, it's unfortunate reality that there are just vast layoffs and terminations taking place as a result of the downturn in business. We had been in the situation of trying to advise employers as to what to do in response to this downturn in business, whether it's a termination, whether it's a layoff, or if you can encourage employees who meet the prescribed circumstances to access job protected leaves under the Employment Standards Act. Just conceptually to begin, there's a difference between a layoff and a job protected leave, in the sense that a job protected leave guarantees your employment throughout that leave, whereas a layoff could potentially turn into a termination if the employee isn't called back within the prescribed time frame. So just these are slightly two different kettles of fish. What's nice for the employee about a job protected leave is that they know whenever business picks up again, they're going to be entitled to come back to work, or whenever the time frame prescribed by the legislation expires, they will have a job to go back to. So in response to this state of affairs, the provincial government here introduced two new job protected leaves for those being impacted by COVID-19 to the Employment Standards Act. So the first is in relation to orders made under the Emergency Management and Civil Protection Act. So for the services that have been ordered to shut down, for example, schools, recreation programs, libraries, childcare, all of these employees are able to access job protected leaves under the Employment Standards Act. As of now, and as I'll get into later in the presentation, that means they're going to qualify for EI, or now the CERB benefit that provides $2,000 a month for 4 months. All of these employees are eligible to receive this, and then it'll be determined by Service Canada and Canada Revenue Agency whether in fact they're going to qualify for the benefits.
I've got a question there. So as it relates to job protected leave compared to a temporary layoff, my understanding of a temporary layoff is that there is a capped amount of time that wherein you must bring them back or else pay out their notice pay. In a job protected leave, is there a different sort of timing framework or requirement?
Yeah, so depending on the leave, the time will run differently than other types of leave. I'm sorry about that. So for example, parental leave is a leave we're likely all familiar with, and that runs now up to 18 months. If it's a different scenario, for example, organ donor leave, reservist leave, family caregiver leave, which I believe runs up to 52 weeks. So there's all different prescribed timelines depending on the type of leave you're accessing. With respect to the temporary layoff, you're correct that if the employee is not called back within the prescribed time frame, it triggers an automatic termination of the employment. So when you're looking at that, you're going to receive the minimum entitlements required by the ESA, which would be pay in lieu of notice, potentially severance pay. And as well, depending on the employee's contract of employment, they could receive common law reasonable notice. So there's potentially massive liabilities if employers are unable to call back employees to work. So if you envision a scenario where there's a long-term employee placed on a temporary layoff and they're not called back, say this employee's been there for 30 years, they have no enforceable termination clause limiting their entitlements on termination of employment, then that employee could be entitled to up to 2 years of pay in lieu of notice. So there's massive liabilities for employers if they're not very careful in crafting these layoffs properly, and also making sure that employees are aware of their ability to access these job protected leaves.
Okay, and we did have a question from somebody regarding how you can potentially help your employees access the current government funding and support systems. Would be going down the path of enacting sort of job protected leave versus a layoff have any difference in terms of your applicability for these programs?
On its face, it doesn't necessarily. I'll give you a lawyerly answer. It depends. So really looking at this, there's again a fine distinction, because a layoff, as I'll get into this more detail later, is the employer triggering this, where a job protected leave is triggered by the employee. Okay. So in terms of qualifying for the benefit, it doesn't necessarily impact on that, but in terms of how these leaves come into play and how you get the ball rolling, they're different processes. From what we've seen from the federal government, they're casting a very, very wide net with respect to these entitlements. So essentially, if you could potentially qualify, it seems like people are going to qualify. And as we see with the latest benefit, they've really, really cast a wide net with who can possibly get it. Right now, it seems like they want to be giving this out to as many employees who qualify as possible.
Okay, so just coming back to it then, because maybe I was a little bit mixed up. Job protected leave is a category of leave that includes all of the things you mentioned. So parental leave and so forth, it's employee enacted. So if you have to take care of family, children or whatnot, and you cannot work, you would say, hey, I need to take parental leave.
Absolutely.
That would be employee determined. And their job would have to be protected if that's the route they take.
That's the case.
Okay.
So I'll touch on that a bit later again as we get into the code a bit deeper. But as of now, what we've seen in Ontario is that if you've been ordered away from work, it's going to essentially be a job protected leave unless it's a layoff. And then, of course, all of the other protections that are available under the ESA as well. So specifically what we see here is that the legislation has captured employees, of course, under medical investigation or treatment related to COVID-19, employees in quarantine or self-isolation as a result of, traveling and being ordered to self-isolate, who are unable to attend work as a result of that. Employees who are directed by their employers not to attend work due to the potential spread of COVID-19. Employees providing care or support to prescribed family members. And again, this prescribed family member is generally a wide class. So it includes your children, siblings, parents, step-parents, foster children, adopted parent, step-grandparent. It's a very, very wide net that they cast. And they just want to make sure that employers are being flexible to allow people to provide the care that, their family members may require. And what's actually nice about this is it provided some clarity to the employment and labor lawyers who have been struggling with this, is that they've made the leave retroactive until January 25th. So what that meant for us is where we were in this scenario before job protected leave who had come in, we were advising, you really don't have a choice but to lay people off and assume all of the risk that comes with it. It's likely going to be the case that the government will introduce legislation to protect jobs. But until they do, we kind of have to go with the layoff. So the advice that we've been giving is start with a layoff and then transition them onto a job protected leave. So what's nice about this from the employer's point of view is it reduces your liability for triggering a termination. And what's nice from the employee's point of view is I know I'm going to have a job to go back to. Okay.
So coming back to that, we had a live question here from somebody saying, if you've already laid somebody off and you're not going to be able to bring them back in that prescribed period of time, is this that mechanism that you'd be using to help extend sort of the layoff period?
Yes. So conceivably, you would canvass with the employee whether or not they fit into any of the protected leave categories. With the expansive legislation that we have now, it will likely be the case that in one form or another they're going to fit into some type of protected category, and you could potentially call them back to work and then immediately transition them onto a job protected leave. So therefore, you're going to reduce the potential risk with a layoff. When you're dealing with the workplace, bear in mind that all of this is driven by general principles of contract law. We're in, the employment realm, but parties are still free to negotiate and agree to what they want, subject to it not violating the ESA or the code, complying with the minimum standards, OSHA, these type of things. But apart from that, employees and employers are free to negotiate arrangements that work for them. So there's nothing to prevent an employer from saying, hey, we started you on a layoff. We want to call you back because we know it's in your better interest to get on this job protected leave. We value you, these type of things to keep employee morale high, and then agree to have the employee go on the job protected leave.
And I'm assuming that this might be in some people's heads. If you're on a job protected leave and during that time you're a business owner, you're trying to figure out if you're going to be able to continue to operate, right? Nobody knows how long this is going to last. Are there implications or are there risks in having somebody on job protected leave when maybe there isn't a job for them when they want to come back?
Yeah, there's certainly risk with that, but it's less risk than a layoff where the time is ticking. Okay, so from 13 weeks you're counting down, and then if you don't have the work for them, the layoff is automatically triggered into a termination and the payout is due. at least with the job protected leave, subject to the timelines under the ESA, which are generally a bit longer, you're going to have more time to get your ducks in a row there. Also, and as well, what we're going to see, I think, and what is in discussion now is if down the road conditions don't improve, employers are going to have the frustration of contract argument available to them, which essentially says through no fault of either party, the terms and conditions of the contract can no longer be performed. And what's nice in that scenario is it triggers the minimum entitlements under the legislation, but not the common law. So it's a massive savings potentially for employers. Obviously, this is all theoretical at this point, and we haven't seen this tested. This line of argument hasn't been tested before the courts, but eventually it's going to reach the point that these contracts will become frustrated and unable to perform for these businesses that are simply unable to recover.
Okay, that's interesting. There was another question here as well that relates to sort of partial leave. Is there such a concept that might apply wherein, you know, you had a full-time worker, you want to move them to half-time to pay them as much as you can or support your business as much as necessary, but obviously that has negative economic impact on the employee. Is there any type of additional income that they could see from the government if they're being partially laid off, or is that currently not being addressed?
No, there is partial payment that they could recover. So basically, Service Canada permits employees to have what's called a sub-plan. So with a sub-plan, Service Canada approves the plan whereby the employee is in either receipt of EI or the additional new benefit, and then the employer can top them up. In all cases, this has to be approved by Service Canada, and it is a bit of an onerous process. So it is available, and for the employers who are looking to make that effort to retain people, it's certainly worth canvassing, notwithstanding that, you know, I would assume there's significant backlog at this point. I read one article that stated there were over 1,200 applications and only 15 case officers to process these sub-plans. And they have to be approved they have to be approved once the employee is already in receipt of the government benefit. So you won't really be able to give the assurance to the employee that it's going to be approved, but it is a mechanism that is available.
So hypothetically, to go down that route, you'd have to first lay the employee off, or that employee would have to take that protected leave, apply for full government benefit, and then be brought onto a sub-plan thereafter?
That's correct.
Okay, all right.
So it's an undertaking, but it is something that it's an option out there to keep people going.
Okay, it's good to know.
Just picking up here. So as I mentioned, the starting point with all of this is the contract of employment. Generally, this sets out all of the terms and conditions of the employee's employment with the company. So you want to be live to that, because in some scenarios, there will be greater entitlements than the ESA set out the employment contract. Some employers offer paid leave, some employers offer unpaid leave. So just be aware of what's contained in your contract of employment and policies as a starting point. Interesting point, if there is overlap between the contract and the ESA, and the employee would think that they're entitled to double dip and take 2 leaves, they actually run concurrently. So if there's parental leave under the contract of employment and parental leave under the ESA, for example, those would run concurrently. It wouldn't be the case that they run consecutively, whereby the ESA runs first and then the contract of employment, or vice versa. So they're not permitted to double dip, notwithstanding that it might be set out in their contract. Sorry, going. One point that you want to keep in mind too is, you know, there's going to be a lot of COVID-related absences from the workplace, and just a best practice right now is to not overburden our healthcare workers. So things like not requiring a medical note, it's very important to keep in mind right now that these things aren't being pressed, and employers are being flexible and reasonable about what they're asking from their employees. I want to move on to probably one of the most important topics that we're going to discuss here, which is constructive dismissal. So when I'm talking about employers assuming risk with a lot of the actions that they're taking in response to the downturn, what I'm talking about is a potential constructive dismissal argument, which is where an employer makes a unilateral and fundamental change to the employment relationship. So the biggest one that we're going to see right now pertains to layoffs. And essentially, employers are entitled to lay employees off if it's spelled out in their contract of employment. Notwithstanding that the ESA has terms around layoffs, if the employer doesn't have a clause essentially stating that from time to time the employer can lay off the employee, that till now has always been deemed a constructive dismissal of employment, which puts the employee in the wrongful dismissal situation. So examples of this that we've seen are decreasing an employee's pay, failing to pay them, stripping their job titles, stripping their responsibilities, maybe a massive change in reporting location. So the law has been pretty well defined with respect to constructive dismissal till now. Employers are generally aware that they have an 8%, 8 to 10% latitude to reduce an employee's pay without triggering constructive dismissal. So for, example, the situation where now this employee is going to have to go to part-time, unless there's a clause saying that, even in that case, unless there's something spelled out, a reduction in pay will be likely deemed a constructive dismissal, same with a layoff. So this is the legal doctrine that we're really, really involved with right now. And basically what the Employment and Labor Bar is theorizing is that, essentially hoping, if you're on the employer side, is that courts aren't going to have much appetite for this argument when they reopen. We're hoping to see some type of reasoning that says, given these, extreme circumstances, we're going to have more flexibility in the doctrine of constructive dismissal. There's one camp suggesting that. I'm a bit more pessimistic because we've seen this time before. 2008, everything went down and we didn't really see a shift in the law. Also, the law is designed such that it's intended to be applied uniformly and not just changing every now and then based on whatever the current economic circumstances are. So this is really where employers are carrying a lot of their risk right now.
And so the primary risk here in this situation would be that you are forced into a situation where you have to lay off a portion of your team, and that you do not have a term within your contract that would govern that layoff. And the employee, rather than accepting the layoff and moving on to government support, says, I'm going to treat this as constructive dismissal, wherein they may be entitled to additional compensation at that moment.
Yes, that's correct. Essentially, they'd try and trigger a dismissal and say they're entitled to whatever their contractual notice is that's spelled out in their contract, or reasonable notice at common law if there's no enforceable termination clause. The issue that employers are going to run into with that argument is, as soon as the termination is effective, it triggers their duty to mitigate. So they have to mitigate their losses. They can't sit on their hands and say, I got fired, I'm going to wait for my dismissal check to come in. And somewhat paradoxically, the law requires employees to mitigate up to the point of potentially staying in that job. So if they're gainfully employed, could continue to be gainfully employed, they might end up with a net, essentially the damages might be moot if they stay mitigating in their role. It's unlikely that employees are going to have a good time going out and finding other work right now. So it would be important that they were making sure that this was just a complete, clean and clear constructive dismissal for raising that argument. But even in that case, the courts aren't even open for them to make that argument in any event. So what this looks like in a year or two when these cases start getting litigated, I'm not really sure. My guess would be that you're going to see a lot of inconsistency in the decisions depending on whether you're getting an employer-friendly judge or an employee-friendly judge. Although the law typically tends to be a bit more employee-friendly, it's not going to be clear what courts are going to say about this. Obviously, it's the reality that employers are having to make tough decisions across the board, and not every employer is going to have valid and enforceable contracts in place that would provide for a layoff. So the question, from a policy standpoint, how are you going to hammer these businesses who are simply trying to do the right thing?
Coming back to that point in terms of trying to do the right thing, we've got a question here about employees, are they allowed to negotiate or agree to a reduction in pay? My understanding, and you can correct me if I'm wrong, is that absolutely, if you have employees who you have great relationships with, you can renegotiate your existing contracts, assuming that they agree and sign them. It's just if you're in a situation where maybe you're unable to negotiate a reduction in pay, you're capped at that sort of 10, I think you mentioned 8 or 10% as a maximum reduction in pay before you're triggering a constructive dismissal. But if you wanted to go deeper than that in terms of reduction, you could simply negotiate it in good faith with one of your employees that you have a good relationship with.
Yes, you absolutely could do that. I would say that any reduction has to be corresponded by some benefit. So what the law requires in this situation is called fresh consideration, and continued employment will not be deemed to be consideration. So in exchange for an employee potentially signing a contract with fewer entitlements that's less generous, you would have to provide, some type of increase in vacation, a signing bonus, some type of other benefit to make this contract legally enforceable.
Could the signing bonus be nominal? Like, could it be a $1 signing bonus just to sort of get by the law there?
It could, theoretically, and the law recognizes it doesn't have to be a whole lot, but I would suggest that you want to make something that's a little harder to pull the veil back on than just the dollar. What the amount will be will, of course, be dictated by the employer's circumstances, but you want to give something that shows a semblance of fairness, not just we're keeping you here for an extra dollar. But with that said, the general proposition, you're correct that they can negotiate a lesser entitlement so long as the employee agrees. And I would also caveat to get this in writing in a properly drafted contract to help mitigate your risk down the road.
Yeah, that makes sense. The other thing that I realized maybe we should have kicked this all off with earlier in this particular conversation is the difference between a layoff and a termination. For me, once upon a time, my understanding was that they were the same thing. I know there's somebody in the chat here today who's under the same impression. Do you want to maybe define those differences? Because we referred to a layoff a couple times versus termination. I know that you're going to have a section on layoffs, that's coming up.
Yeah, so we'll just speed ahead. So a layoff occurs when the employer temporarily stops providing work to an employee with the understanding that the employment relationship continues, okay? So while an employee is on layoff, they're still an employee of your company. When an employee is terminated, full stop, that's the end of the employment relationship. So what gets thorny here and a bit confusing is where the point where a layoff crystallizes into a termination. And that would be after whatever province's statutory period expires. So in Ontario, employers are typically entitled to lay an employee off for up to 13 weeks. Or no more than 35 weeks and 52 weeks for certain prescribed situations. In any case, once that timeline expires, the layoff automatically turns into a termination of employment. Full stop, the employment relationship comes to an end.
And that's and at the termination point, that's when entitlements become realized. So if you're laying somebody off, there's no notice pay or termination pay that's due.
No, and you would in fact be required to continue making the group benefits payments on behalf of your employee, things of that nature. So their seniority would continue to accrue, but with the termination of employment, that's when your entitlements get triggered again, pay in lieu of notice, severance pay if applicable, and then potentially common law notice if there's no termination clause limiting that.
Okay. Yeah, I was even lost on this until recently.
Yeah, it's not a clear area of the law, and I think there's a lot of misconceptions floating around. And as well, for the people in here, I'm happy to circulate these slides after. I know we're moving quite quickly here, but I'm happy to circulate them so you can see in a bit more detail. In terms of affecting a layoff, employers are commonly coming to us for advice right now. There's no prescribed form to do this. You don't have to, pull a form from the Ministry of Labor, for example, to put somebody on a layoff. You just really have to give the employee notice that they're being laid off, and you could say effective immediately. I would caution, though, more notice the better, just out of fairness in what people are dealing with at this time to give them a bit more opportunity to get their ducks in a row. And as noted again, if the requirements of the legislation aren't followed, then it's going to turn into a termination. You want to keep that date in mind, though, the 13 weeks, and make sure you're ahead of that for the recall, because a lot of the law says if you're late by a day, it doesn't matter, it's going to be a termination. So there's not a lot of flexibility on extending that date if you don't get it right. Again, as noted, if you don't have that spelled out in your contract, you're going to run the constructive dismissal argument. Honestly, it's not great, but what I've advised my employers now is run the risk if it keeps your doors open and deal with it down the road. There's really no benefit to just rolling over on this and saying, oh, well, it's not in my contract, I'm just going to pay everybody out and close my doors. Depending what the courts say and what the approach is to this, I think it's better to delay that risk for the short term and see if when this calms down, you can pick things back up and, keep people employed for longer.
There was another question with regard to, people returning from work, which was, if somebody is laid off and it was processed as a layoff, not a termination, when they return to work, and you're talking a lot about the specificity of those dates, would you usually have another document signed that indicated that they're restarting work, like a new employment contract or some other form or document that indicated that there was a restart to the work?
Certainly not an employment contract unless the terms and conditions of employment have changed. As I mentioned, through a layoff, all terms and conditions of employment are essentially frozen. So employment continues through that period. When they return to work, if you just want to note it for their personnel file, it might be something to do. But the more so the concern is just getting them back within the prescribed time frame. So during the course of the layoff, you would issue them a notice of recall, a written document saying basically you were laid off on X date. You are now being recalled to work on Y date. You're expected to attend at your regular place of employment at your regular start time, essentially.
Yes, it's not a simple form. It wouldn't be a full new contract.
No, it would just honestly, a letter or an email will suffice, just saying you're being recalled to work in accordance with the Employment Standards Act.
And then, there's another sort of tricky situation that I'm sure a lot of people are finding themselves in, and it was a question as well. If you paid some notice pay when you were laying somebody off, so let's just say you lay somebody off, on Monday, and you're going to pay them for that week, almost like a notice period, because maybe it's because you misunderstood, the difference between a termination and a layoff. But in any case, you paid notice pay, but it was just a layoff. If you are to find yourself at the end of that layoff period and you are then terminating at that point, do you have to still pay notice pay if you've already paid it, or would you owe it again because that previous pay isn't recognized?
Certainly, if I was wearing my employee hat, I would tell you that you have to pay it again. I would say, you paid me for the week. It's not notice because I wasn't terminated. It's an additional benefit I derived. That's fine. If I was wearing my employer hat, I would say, mistakenly, I already paid notice. This should be deducted from the overall quantum of notice that the employee is owed. But I don't think it's the strongest argument if the employee, in effect, sits on that 13-week layoff and has their employment continued through there. I wouldn't love making that argument. I don't think it would be the strongest argument. But nonetheless, I would make it if it was in my client's interest and I thought we could recover it.
So this is a bit of a gray area.
It's certainly a bit of a gray area. I would do everything possible to not characterize it as notice. Typically what you would see with say you paid out vacation pay, for example, before putting the employee on EI, typically you'd see that affect the eligibility period for when the employee gets EI as the money's continuing to come in. But now, since they've waived the waiting period, I'm not certain that would be the case. And I think, again, the government's plan is to get as much money into people's hands as possible right now. But I think it would be a legal argument worth some debate, to be honest.
Yeah, that makes sense. We have somebody here, just for the record, it looks like we're going to run, relatively over here. I know that there's a lot of content, there's a lot of questions, and I know that we haven't had the opportunity to get to all of them yet. Just to close out a previous question though, if somebody was cut down to 50% of their pay or 50% of the time, that would not be considered a layoff, right?
No, it'd likely be considered a constructive dismissal.
Okay.
If they brought that claim.
Unless it was negotiated with the employee, and with and fair compensation was given for that change in contract.
Yeah, certainly the parties could agree to that.
But they would not be eligible for EI if they were still being paid.
Well, again, subject to the subplan. So if the employer goes through and gets a subplan in place, then they could do it. But if they're continuing to be employed, they likely wouldn't be eligible for EI.
Okay.
And I would caveat that all determinations of EI are made by Service Canada and Service Canada alone. So it's a bit of a tricky area to provide EI advice when we ultimately can't insert ourselves and have a say in that determination. So certainly there's a whole pool of employees who will be eligible for EI and government benefits, but that doesn't mean they're entitled to them. Okay. So that decision is, again, always going to be made by Service Canada and Service Canada alone.
And there's no disputing it. There is no court of law for Service Canada's determination.
There may be an appeal process. To be honest, I haven't come across it. It's something I'd have to look into, but off the top of my head, I don't know.
Okay, fair enough.
I don't know how many questions you have coming in, but I'm happy to field questions if they're flowing in, and then we can circulate the slides and people can brush up on the last bit. If they like. Or
the other component here is, there's quite a few slides left. There are quite a few questions. There's an opportunity for us to potentially follow up this webinar with another webinar, maybe next week. We're going to shoot off a poll right now, just asking you to be interested in sort of a part 2 if you want to continue the conversation, based on the poll that should be up on your screen right now. We may decide just to extend this. So, because there is quite a bit of content that's left, and there are definitely quite a few questions. We can try to get through a few, but knowing that we only have 5 minutes, it's doubtful we'll probably make it through everything.
Yeah, absolutely. So just flipping forward to the new emergency response benefit. Essentially, if you have employees who have already applied for EI, they need to stay in that stream. Now, when you're advising employees about what potential benefits they can get, this is a very, very wide net, and it applies to all wage earners, contractors, basically self-employed. If you can't work as a result of COVID, it seems to be that you're going to be eligible for this benefit. It's $2,000 for up to 4 months. After that 4-month expires, employees who are EI eligible can still apply for EI after it finishes. So what's attractive about this is it's more than one some employees would make in a month. And 2, it's more generous than EI, the maximum payment. EI, I think, is around $500 a week, maybe up to $600. So it's in that ballpark and quite generous in my view. So certainly you can advise employees that, the government's doing everything they can to get employees access if they're out of work as a result of COVID. So you can direct them there. And it says essentially that within 10 days, they expect to be able to grant applications. So yeah, it applies to anyone who lost their job, who's sick or quarantined, taking care of someone with COVID or is off work and must stay at home due to school closures. So very, very wide net. Can expect to receive the benefit 10 days after applying, and again, runs for 4 months.
And there were some people who were interested in, your ability to potentially, help out during that time. If you were temporary, so if you're temporarily laying somebody off, you could continue to pay for their benefits. Could you improve their benefits to give them access to some additional capital? So would you be potentially allowed to lay somebody off and then increase their HSA allotment or something like that if they wanted to spend it on mental health? Or
you could, but I would say that would be subject to the direction of the benefits plan provider. I don't think a lot of benefits plan providers would be in a hurry to increase entitlements in these times, particularly where people are going off work. But I'm not sure. Certainly if it's a payment the employer wants to make unilaterally, they're free to do so. But as it relates to, a particular benefit plan policy, that would have to be made with the benefit provider.
Well, that's fair. We're actually going to be running, we haven't announced it yet, but we're going to be running another webinar in short time that covers some of the implications to group benefits, as well as some strategies on reducing costs for benefit plans. So we can touch on that then. I think you've done a good job though covering this. I'll let you continue. I apologize.
No problem. Though, just to I want to get to this temporary wage subsidy that's available to employers. So essentially between March 18th and June 2020, the federal government's offering 10% of remuneration pay to employees, $1,375 maximum to employees for a maximum of $25,000 per employer. So this is, of course, to help offset the downturn in business that many employers are facing. So it's another stream that employers can help, lessen their losses in relation to COVID. So
Yeah,
certainly,
and if anybody wants additional information on this in particular, we put up a really great resource on our COVID page. As well, if you're a client of Humi using our payroll system, we're supporting these deductions. We're actively making sure that this is a really easy process for clients. So if you haven't reached out and you are on payroll with Humi right now, please make sure that you're reviewing that information. We're here to make sure that that's an easy process and that everybody's getting access to that capital.
Yeah, so I'm just going to end off with a little piece on human rights here. What you don't want to be doing is discriminating against employees in a manner that contravenes the code. Some types of discrimination in the workplace are, of course, are permitted. I don't want to hire you because you're not smart. Totally fine. The code really contemplates prohibited discrimination based on the grounds that are listed out. So you're talking about race, ethnic origin, gender, citizenship, family status. So in terms of COVID, what you want to do is make sure that if you're taking, any action against an employee, dismissal, termination, it's not related to disability as a result of COVID. So as I mentioned, it only has to form part of the analysis to breach the code. If any part is related to a prohibited ground, that will be a breach of the code. So
Nathaniel, I hate to cut you off. I know we've got a lot of content and a lot more questions, but we've kind of run through the hour here. I think the software is going to boot us off in a minute. We're going to have a recording of this that we can share with everybody who's on the call today. We can share additional commentary and sort of a summary of some of the questions that were asked and the answers that were provided. And we'll also look at the poll results there to see if maybe we run a second webinar. But for now, I've got to thank you, Nathaniel. I really appreciate you taking the time to help our clients and anybody else who joined today. These are really tough times, and it's great to see everybody banding together to help one another. And obviously we want to help however we can, and really appreciate your time.
Oh, thank you for having me. And of course, if anybody who attended today requires any specific advice, please feel free to reach out. I'd be happy to hear from all of you. And thanks for your time in attending today.
Cheers.